Monday, February 26th. It is now 5 o'clock. And so we will call today's Board of Adjustment meeting to order. We will start with the roll call, starting on my left, and ask that everybody state their name and if they have any conflicts with today's agenda item. That I'm being heard? That we're being heard online? Oh.
Do it one more time.
What do we need to do?
Okay, good to go. Thank you. Sorry.
Do I need to start over?
Yes, please.
Okay, calling the meeting order Monday, February 26th, Provo City Board of Adjustment meeting. We will start with roll call, have everybody state their names and if they have any conflicts.
Eric Chase, I have no conflicts.
Lori Urquiaga, no conflicts.
Maria Winden, no conflicts.
Amanda Peterson, no conflicts.
Andrew Rank, no conflict.
I should state that I am the vice chair and I'm just filling in tonight for our chair who could not be in attendance. I just want to read a few things at the beginning of the meeting. Although this is a public hearing, only the presenters and those invited by the committee may speak, excuse me, may speak or ask questions unless otherwise invited by the chair. In this case, vice chair, please wait to speak until called on. When speaking, please be sure to speak into the microphone so that the record is clear. Please state your name and city of residence for the record. Please limit side conversations as they interfere with the audio recording. If you need to have a side conversation, please step outside of the chambers. Please do not attempt to interrupt or speak over people. Intimidating or threatening speech or behavior will not be tolerated at any time. And also please refrain from clapping, cheering, booing, or being otherwise disruptive during the meeting. Just a review of this board's authority. We can grant variances or act upon an appeal that is limited to specified city ordinances such as exceptionally irregular or narrow or shallow or steep lots or other exceptional physical conditions whereby strict application of an ordinance would result in practical difficulty or unnecessary hardship that would deprive the owner of the reasonable use of the land or building involved. But in no other case, the Board of Adjustments makes decisions on variance requests based on evidence and may only grant a variance if there is an unreasonable hardship related to the property that is denying a substantial property right. We may not consider financial, personal, or self-imposed reasonings for variance request. In granting variance, the board shall prescribe any conditions that it deems necessary or desirable. Granting the variance will be in harmony with the general purpose and intent of the ordinance and will not be injurious to the neighborhood or otherwise detrimental to the public welfare. Neither personal nor financial hardship can be considered as justification. I'll now read the agenda item into the record. Tim Anderson and Barbara Mapes, I apologize if I mispronounce your name, request a variance from section 14.10.080 to reduce the side yard setback from 10 feet to 8 feet to accommodate a patio roof in the R1.10, the single-family residential zone located at 3737 North Foothill Drive in the Sherwood Hills neighborhood. And Nancy Robinson, city staff, will present this item to us at this moment.
Thank you, Board. I'm Nancy Robinson. So let's see. So this is the slide. The current legal use of the property is single-family residence. The catalyst for this hearing was a code enforcement call. Mr. Anderson had put in a cement pad with a roof tied into his existing roof on the north side of his home. He applied for a permit post facto in June of 2023. Oh, sorry, I should go back. On the first page, there is one correction on the alternative action. If you decide to continue, the future date should be listed as March 18th of 2024. Sorry about that. Okay, so he applied for a building permit post facto in June of 2023. Initially, the patio passed inspection based on the drawing. So this is the drawing that was submitted with his building permit application, and it showed that the structure would be 16 feet and 6 inches away from the property line. You can see that in the, if this works, you can see that it shows right there 16 feet, 6 inches. That was what was submitted for the building permit. So a neighbor contested that final decision. Our building inspector went to the property and his report states as follows: a direct sight line was established. So this was our building inspector. A direct sight line was established from the two property corners to verify the actual property line. And then measurements were taken. The support posts for the attached roof extension measured 7 feet, 8 inches from the property line and 22 inches of the eave encroaching further. The date of the inspection was September 7th, 2023. So the property is in the R110 zone. The minimum side yard setback is 10 feet. The applicant is asking for a 2-foot variance. If the board were to grant the variance, the applicant would actually need 2 feet 4 inches for the current placement of the posts. So literal enforcement of this title would not cause unreasonable hardship for the applicant. The property owner can continue to use the property as a single family home and still has use of the patio. The surrounding properties share a similar shape and topography as the subject property. Granting the variance is not essential to the enjoyment of a substantial property right. The property allows for a patio to be built within the required setbacks. The variance would not substantially affect the general plan, but may be contrary to public interest in maintaining orderly and consistent application of the zoning code. And staff feels that the hardship in this case has been self-imposed and therefore is inconsistent with the title. Additionally, denying the variance is not unjust because the applicant has other options on his property to create an additional patio within the required setbacks. While staff understands and is sympathetic to the applicant that the patio is already built and it is in use, zoning ordinances for setbacks have been established to maintain minimum landscaping between buildings and a separation between homes to reduce the chance of fire to spread from one building to another. If the Board of Adjustment grants the variance, it would need to be 2 feet 4 inches to accommodate the current placement of the posts. Staff recommends that the Board of Adjustment deny the requested variance to reduce the side yard setback. Do you have any questions for me?
Are there any questions at this time for staff? None? Okay, none at this time. Okay, we'll have the applicant come up to give their presentation. You'll have 15 minutes for your presentation. When your time is up, you'll hear a ding. And following your presentation, if we have any questions, we'll invite you to stay forward and answer those questions.
Good evening. My name is Philip Balloff. I am an attorney and I'm representing Timothy Anderson and Barbara Mapes, the applicants. This variance application comes to you in the context of a boundary dispute between the Andersons and the resident on the north, Mr. Bohannon. This boundary dispute is central to the resolution of this variance application because the measurements that appear to have been taken by the city to initially grant the variance, and then subsequently, after a reinvestigation or remeasurements, were found to be not within the 10-foot side yard setback restriction. And the problem is that the resolution of, or the determination of whether the improvement, this roof extension, is proper depends upon the boundary line. In other words, how far you measure north. And once you determine that boundary line, you can determine whether the applicant needs a variance or whether a variance is not required. I want to make sure that the board has received the applicant's additional submission of materials. When I spoke with staff earlier today, I was told that you hadn't yet. I hope that you've had an opportunity to review it, because it presents a quite different story and set of facts than the staff has presented to you and based their recommendation on. To begin with, I'm a little concerned about this photograph that they showed you of Doug Fallon's measurement. I've never seen that photograph before. I did a grammar request for my clients so that we would know what materials the staff had in front of it when they were going through this process. And this measurement over the top of a block, I've never seen that before. And it seems out of context to me, because the block wall is not, I mean, that's a cinder block. And the block wall is not anywhere near this roof extension and concrete patio and stairs where the measurements should be taken. So that concerns me. Secondly, the drawing that supposedly showed the dimensions of the patio, I've not seen that either, and didn't receive a copy of that in my grammar requests in order to prepare for my client's position here. But let me summarize what I believe to be the essential factual circumstances. In 2018, Mr. Anderson built a small extension on the north side of his home, a roof. And prior to commencing work, he had a third-party contractor do the work, but prior to commencing the work, he contacted the city and was told that he didn't need a building permit. So he proceeded to have that done by a third party. The neighbor to the north, Mr. Bohannon, didn't object, didn't complain, didn't say anything at that time in 2018. And there were no issues with respect to that roof extension. In 2022, Mr. Anderson wanted to put a concrete patio from the edge of his home to the north of the property in order to put that, so that would be underneath the patio, and then put some stairs going down the slope of the property towards the west on the northern boundary. And he himself prepared the frames for the concrete pad and the stairs. And then he hired a gentleman by the name of Thomas Noakes, who was a concrete subcontractor, to come out and do the pour. And on the day he came out to do the pour, Mr. Bohannon, the neighbor to the north, put up a string line from the east side of his property to the west side of his property, bordering the two properties, adjoining properties. And Mr. Anderson and Mr. Noakes have submitted declarations sworn under oath that at that time that Mr. Bohannon said to Mr. Anderson and to Mr. Noakes, as long as you are pouring on the south side of the string line, then you're not on my property. And based upon that representation and the string line and where the forms were placed, which were on the south side of the string line, they proceeded to pour the concrete patio and stairs. Mr. Bohannon, during the 3-day process of this work, according to Mr. Noakes and Mr. Anderson, came out and said, it looks good. Looks fine, didn't complain, didn't object, didn't say that it was on his property. It wasn't until months later that he began to object. And as the materials that I've submitted to you, both the affidavit of Mr. Anderson and my narrative indicate that in sometime in approximately October of 2022, Mr. Bohannon's attorney sent a letter to Mr. Anderson. That's when I got involved and responded to Mr. Bohannon's attorney, and we had some back and forth. And I raised with him, with his attorney at that time, the principle, the legal principle or doctrine of boundary by estoppel. Boundary by estoppel is a recognized principle of Utah law, where if a landowner makes a representation regarding the existence of a boundary and another person relies to his detriment on that boundary, that can constitute and give rise to a new boundary between them because of that reliance on the statement. And that's exactly what happened here. Mr. Bohannon made a statement and he put up a string line and said, if you're pouring on the other side of the line, you're on your side of the property. And that's the problem. That dispute between them is the problem. Now, I recognize that as a board of adjustment, you're not a court of law, and you're not in a position to make decisions as to what the proper boundary line is based upon legal principles. Nevertheless, in order for you to determine whether a variance is required or a variance is appropriate, this issue, this dispute of boundary, what's the proper boundary line, is paramount and needs to be resolved. And to simplify, I think, the process of getting this resolved between these neighbors who can't see eye to eye on this matter, the best course of action, I believe, is for this board to table or defer any further action on the application and to refer this matter to the 4th District Court so that a judge can resolve the issue. And my client is prepared to initiate the appropriate proceedings in court in order to have a judge decide where the boundary is. Once the boundary is determined, then either Mr. Anderson won't need a variance, or if he does, then we can return and argue the reasons why a variance is necessary and appropriate. But again, the other important fact here is that that the initial investigation that was done by the city representative, and it was, I believe, Robert Allen and an officer, Zelaya, they came out and did measurements. And I don't know because I wasn't there and his report doesn't make it clear, but the photos that I've attached to our papers suggest that his measurement was from the house edge to the edge of the concrete patio stairway, which is the boundary by estoppel point that my client maintains. And at that time, when Officer Zelaya and Mr. Allen made those measurements, he said that the improvement is within the proper 10-foot side yard setback requirement. In fact, he said it's 10 feet 8 inches away. So apparently, and from what I've seen from Mr. Bohannon's submissions to the staff, Mr. Bohannon has made multiple requests for investigation and revisiting this issue that was measured and reported by Officer Zelaya and Mr. Allen. There's been different measurements reported based upon Mr. Bohannon shooting his own boundary line based upon GPS. And so he's giving a different boundary line to the staff who go back out to measure than what Mr. Allen and Mr. Zelaya used. So there's this conflict in the Provo City's investigation record between what is the right boundary line to make the measurements from. And so I think we need to resolve the boundary line before we can start measuring to determine if a variance is necessary. The photographs that we have submitted, and I'll draw your attention specifically to the declaration of Mr. Anderson, shows the string line. And if you look at the photographs in Exhibit A to Mr. Anderson's declaration, you'll see the picture, the first picture there shows the string line. And it shows the string line before the concrete pad has been, I'm sorry.
I'm just wondering if we can get that document displayed. Yeah.
Okay. So I'm looking for exhibits A. This is a different set of exhibits, I think. All right. So do I just push the button to have it advance? And where do I aim? I'm pushing and I don't see any. Okay, here we go. This way?
You probably need to push on either side. That's going that way.
Okay.
That one's going that way. Yep.
All right, so we'll go this way. I'll come back to those. This is the photograph I want to call to your attention. This white line is a string line that I referred to earlier that Mr. Bohannon placed. This is on the day that Mr. Noakes came out to prepare to pour the concrete. And as you can see, the forms are visible. You see the forms visible on the left, that's the south. The line is the string line that Mr. Bohannon put. His property's on the north. And there you'll see that the string line is an inch further from the 2x4 there, the concrete of which is being poured left of the edge of that board. I can't seem to, there we go. Again, the line continues and these are the additional forms for the stairs. The stairs are on the left side of the string. And the line continues down to the east side of the property. Mr. Bohannon, again, because of his disagreement with Mr. Anderson, has spray painted X marks in orange and other marks on the concrete, again, disputing the fact that the concrete is properly on Mr. Anderson's property. And he has cut down an aspen tree. You can see the aspen tree there on the right inside the concrete area. He cut it down. Sorry, I apologize for my. This shows the significance of the disagreement that seems to me to require court intervention and involvement. The other, I don't know how much time I have left, but the other point that I would like to make is that we've provided photographs as well, and those were the photos at the beginning of the, and I'll go back to them here. So this photo, these two photos are from the city. I got them through a grandma request. And these are the photos that Mr. Allen and Mr. Zelaya took showing the measurements that they've made at that time and that support their position that there was no need for a variance, that there was no non-conformity with the setback requirement because it was within the 10-foot requirement. But these photos, which my client took in the Sherwood Hills neighborhood, show what appears to be improvements being made on properties that are as close to the boundary as his. And he feels that there is an inconsistent application of side yard setback enforcement, or that perhaps if there's no disagreement between neighbors, it's because they're getting along and being reasonable with one another. And it's another reason why I think a court needs to resolve this, and why we would ask this board to refer the parties to the 4th District to resolve the boundary issue before the issue of a need for or the appropriateness of a variance is addressed. And you might say, well, then why did Mr. Anderson file an application for a variance at the beginning? And that's because he was told to.
Okay, thank you very much. Appreciate that. Oh, go ahead.
Just one clarifying question. When those photos that you showed with the spray paint and the string line, is it being contested that that is in fact the property line, or that that's in fact where the setback ought to take it back to?
It depends on which photo you're referring to, because there have been multiple string lines that have been placed on the property by Mr. Bohannon over the course of time. The first string line that I showed you, where the concrete pad and stairs had not yet been poured, that was the string line that Mr. Bohannon put up in July of 2022, at the time that Mr. Anderson was preparing to pour the concrete. But in the other photographs where you see the orange paint, the X and other marks, there's a string line that Mr. Bohannon put up at that time. And those string lines are a different boundary line. It's not based upon the string line that he put in place when Mr. Anderson poured the concrete. And when Mr. Bohannon said, if you pour on your side of the string line, you're fine. Hopefully that helps answer the questions, but if you want me to look at a specific photo, I can do that.
No, I think that answers it. I guess I was just curious if ultimately there were more or other structures at play beyond this, one roof overhang.
My understanding that as far as the variance is concerned, the variance is with respect to the roof extension, not to the concrete pad or stairs. I think maybe I misheard Ms. Robinson, but I think she said that the variance was with respect to the concrete pad, but I believe it's not. I believe it's the roof extension that we're talking about. But the measurement needs to go to the boundary line, and the boundary line, based upon the principle of boundary by estoppel, is the edge of the concrete, or actually an inch or two to the north, because of the string line was an inch or two to the north. It was an inch north of the 2x4. Concrete was on the other side of that.
I have a question for staff. It seems like the more compelling question right now is the boundary issue, which is not something that this board is able to resolve. And so,
I would disagree.
okay,
I don't think the location of yeah, it's on. The light is on. Is it not picking me up? Can you hear me now?
yes.
If the court rules that a variance is not necessary, then any decision you make tonight would become moot. To me, the location of the boundary line is somewhat independent of the criteria necessary for approval of a variance. And it's the staff's position that this, regardless of where the boundary line is, if a variance is necessary, and we're willing to let the court make a decision on that. But if a variance is necessary, this is very far from meeting the criteria for variance approval. There's no substantial property right that's being denied. There's nothing unusual about the piece of property that's not common to the neighborhood. It's just very far from meeting the criteria.
May I ask who this is? I'm sorry, forgive me, but I don't know who you are.
I'm Bill Pepperoni. I'm the Development Services Director.
Thank you. Appreciate that. May I respond to that? Or no?
No, it was just a question for
Okay.
staff.
Okay.
I think I need to ask Mr. Bohannon because I can't tell whether that string was supposed to be on the lot line or on the setback line. But I don't know that it matters anyway, because if the line, that's not something we can decide. But looking at the pictures, it's hard for me to tell what I'm looking at.
Do we have any further questions for the applicant before we have any, before we open it up for more comments? Okay, thank you.
Thank you.
Okay, we'll now have open the hearing up. Oh, first, if there's any, if the neighborhood district chair is here for any comments. If not, we'll open it up to, did I see a hand?
Yeah, I spoke to our neighborhood district chair before I came.
Oh, come up to the microphone, please.
I'm Ron Bohannon, the neighbor to the north. I spoke to the district chair, one of them, before I came in today.
Which neighborhood, which district?
District 1.
We do have a district representative here.
Okay,
Oh, we do?
Sorry.
Hold on to
Or
it.
did you speak to Stan?
Yeah, yeah.
So I'm the neighbor district chair. I wasn't aware that you were in contact
No,
with
I
Stan.
also
So
talked
that's
to,
good to hear because he's
I
your
talked to
neighborhood,
Richard Pratt as well.
which is
okay,
your direct
let's just have the
neighborhood.
Yeah.
district chair.
I've only been reading the emails. I agree that it doesn't sound like it meets the criteria for a variance, but it does also sound like the boundary dispute needs to be settled.
Right. Yeah.
But I would be curious to hear what Stan
Yeah,
has to say.
yeah.
He's a lawyer.
Shall I say something or no? Or stand there? Nancy.
Sharon Mehmet, District 1 Neighborhood Chair.
Okay, thank you. Okay, we'll now open it up to public. You'll have, please state your name and the city that you live in if you have, and you'll have 2 minutes to comment. You'll hear a ding and then the microphone will be muted.
Okay, I'm Ron Bohannon, the neighbor to the north, and I agree with what they were saying, and I have to be careful how I agree because it's often misconstrued. When we put the string line up, which seems to be the contention that they've been using from the start, I put it on like right when he was framing that before the guys came out. And the reason I put it up is because Tim and I, neither one of us knew where the property line was. So I called one of the previous owners, Scott Baird, and asked him if he knew where the boundary line is. He said, when he put in the sprinklers, that was his profession, sprinkler guy. He says, I put it right on the property line. So I got some string and I ran it between the two sprinkler heads. And then shortly after that, the rear sprinkler was moved and broken. And then the string line was moved over about 3 feet. And we went back and forth. I kept putting it back. I paid Dudley Surveys to survey it. I brought a copy of that for each of you right here. Mr. Anderson and I have been debating the property line from the beginning of his side yard projects that I felt he was encroaching in my yard. He brought an excavator in, started cutting up the yard, and I said, I think you're out of line. And we went back and forth, and the string moved pretty much twice a week, 3 times a week. And every time it moved, I put it back. And when the concrete guy was there, Tim had reset the string the previous day. And I told him that I think it's fine, whatever he's building, it's beautiful, do it on your property. But neither one of us really knew where the property line was. He kept moving it where he wanted it. And I asked him if he had a real survey, and he said, no, but
Thank you.
Mr. Bohannon?
If the time's up, if you submitted pictures, then we'll get them. If anybody else from the public wants to make a comment, come on up, state your name, please.
I'm Cynthia Bohannon. I wish I could have been there on the day that the bulldozer suddenly appeared. They asked for permission to come across our side yard, which is pretty rough construction. So it made sense that maybe where he was going to dig he could come across ours. We said no, of course, because by now the contentions were rising a little bit. So he came across his grass, dug a nice scoop, and started putting in the red brick, along with the roof went in right after the pour of the cement. So there's some misinformation going on here. Mostly, I just want to say, if he had filed for a permit when he was putting the structure in and gotten the survey done, we wouldn't have had to cough up the money we did just to put the dispute aside and be able to solve the problem. That's all I have to say.
Thank you. Is there anybody else from the public that would like to come up and make a comment? Seeing no further comments, we'll close for public comments and turn it back over to the board for discussion.
I think the way that I'll get started, if that's all right. The way I'm seeing this is that there is a question about where the boundary line is that I think ultimately, for the purposes of the board, is largely immaterial in that, we just need to answer the question, is there a variance that could be justified in this situation? And I think the answer is no. I think the question is not whether or not a variance is justified, because I think it's not. I think the question is whether or not a variance is needed. And I don't think we have to answer that question today.
Time's up.
I agree with you, Andrew. I think that it's clear that there is some question about where the boundary is, but that the question before us is whether or not a variance is justified. And based on the way I understand the statute, the ordinance, it's not something that we could grant. So we would have to simply say, depending on where the boundary is, that's what needs to happen.
Which would de facto pass that question on to
the court.
I had a question about that, of seeing that the applicant wanted this to proceed to the higher court anyways, would the proper course for us then to just be deny it so they could dispute it, or am I missing something?
I mean, as the legal advisor here, I'd say that doesn't preclude them from taking their civil action. In the end, the question of if there's a variance that's what's before you. So I think they're asking for it to be denied. They could have just withdrawn, but that's, in the end, you got to apply the ordinance as you see it, and then they'll move from there with what options they have elsewhere.
Okay. I think I'm feeling the same as the other people, that they're there's probably not justification for the variance in this case.
I would agree with that. I think it's in our responsibility to be able to say yay or nay on this variance, and I'm comfortable saying I don't think that it would cause an unreasonable hardship if it were denied.
I'm prepared to make a motion if
Please.
you're ready.
Mhm.
Could you put the item back on? I move that the Board of Adjustment deny the variance from section 14.10.1080 requested by Tim Anderson and Barbara Mapes to reduce the side yard setback from 10 feet to 8 feet to accommodate a patio roof in the R110 one-family residential zone located at 3737 North Foothill Drive.
Is there a second?
I'll second.
All in favor? Starting at the left.
Aye.
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 It's unanimous. And so just,
My understanding is that the city will not enforce the issue until they've had a chance to look at the boundary dispute. Is that the way it works? Based on what you've said, or is that?
I mean, I guess I think that sort of be left up to the zoning officers and people within it. I don't think there's a definitive answer as to how it will proceed. We'll sort of need to see what happens next,
But it can be stayed by litigation if the court says so, I assume.
I mean, yes, I think they can impact things, and we just need to see what actually is going to happen, right? I think we can't make guesses or promises as to how this will be handled when the lawsuit is entirely hypothetical at this point, you know?
Okay.
okay, we have no further items on the agenda. And so is there a motion to adjourn?
I move we adjourn.
I'll second that.
Okay, we will close the meeting.
In favor?
Thank you.
Aye.
Aye.